Welcome to Gosfield and Shea on Health Law.
Hey everybody, welcome back to an all-new episode of Gosfield and Shea on Health Law. I'm your host, Mike Leon. Dan here is a healthcare attorney focused on regulatory compliance for physicians, including HIPAA, Medicare billing, fraud and abuse, and emerging legal issues in electronic health records and artificial intelligence. He's known for making complex rules practical and accessible for medical practices. Perfect, because that's what I want to learn about today. We needed to break it down, right? In today's episode, we're going to take a look at HIPAA, right? We'll discuss what it actually requires, where practices often make mistakes, and how to manage compliance realistically. So, Dan, good to see you as always. Let's start with this high level. Tell us a little bit first about your background and what led you into this kind of work.
Thanks for having me here today, Mike. So it's actually kind of an interesting story. Gosfield, Alice Gosfield and Associates is a family-run business. Alice is actually my mother. And the way that I got into this was never my original plan. I graduated from law school into a not fantastic job market. And at the time, I was looking around for a job, and Alice had just had an associate leave the firm. She needed someone to step in and pick up the work. I needed a job, and she said, "Well, I know how to, tell you what to do." I said, "That's true." And she said, "So come work for me. I'll train you to be a really terrific lawyer, and you'll learn about health law." I had not been interested in health law when I, was in law school. But the more I did it, the more interested I became. I now have much more of a personal connection to it because my wife is actually a doctor. But that is basically how I fell into healthcare law.
So that's interesting because it funnels into this follow-up question. Now that I know you're married to a doctor, what is one of the biggest things that that these doctors tend to misunderstand about what HIPAA actually requires? And in your answer, if you could explain a little bit more of what HIPAA, the acronym, stands for as well.
HIPAA is the Health Insurance Portability and Accountability Act, HIPAA, not HIPPA. People misspell it sometimes when they're typing it out. It's basically a law that governs the privacy of medical records and other information relating to that, like billing records and that sort of information. All of that is referred to as PHI, or protected health information. As far as the common mistakes, it's interesting. There's kind of a continuum where doctors make mistakes. On the one hand, you can have physician practices that are not taking HIPAA seriously enough, not engaged in enough oversight. They're only dealing with the basics of ensuring privacy without meeting all of the remaining requirements, and there are many. On the other hand, you can sometimes have doctors who are a little overly vigilant, and they may say things like, "Oh, I can't release this information because of HIPAA," when in fact HIPAA would allow you to release the information. Having a clearer understanding of what the requirements are and how to navigate those requirements is kind of where healthcare lawyers come in. We help our clients with that sort of thing.
So Dan, let's stay a little bit on the enforcement part of this because you mentioned there's two tracks where some doctors are loose, some are a little over vigilant. But for all of that, what does the enforcement process looks like when somebody actually does violate HIPAA? And how do most of these investigations start? And tell us a little bit as well about the Office of Civil Rights and what they focus on.
Sure. So one of the tricky things about HIPAA is that anyone can file a complaint. It's not just the patient who is the subject of the records. Someone in your office who is on your staff could think, "This isn't right, we're doing things wrong," and they can file a complaint. Now, the Office for Civil Rights, which is the government entity that's responsible for enforcing HIPAA, doesn't necessarily enforce against every practice for every single complaint. They will conduct preliminary investigations, and then after the preliminary investigation, they may do a deeper dive to find out more information. If based on the preliminary investigation, they saw some potential problems. one of the first things that they're looking for is prompt responses from physician practices. When you get a notice from the OCR that you're under investigation, you need to be taking that seriously and responding to it. That's not, a letter that you put at the bottom of the pile. Most physician practices understand this, and so they're usually likely to respond. But there are stories out there about doctors' offices just ignoring the OCR's inquiries and not taking it seriously enough, and they usually end up in hot water as a result of that.
Is that probably the most common mistake that you see that leads to a HIPAA investigation, or are there other ones that are like even so small and simple that could still trigger an investigation?
The common mistakes that I see, the really common mistake is I would say there's at least two of them that are especially common. One is not having policies and procedures and not having conducted what's called a security risk assessment or a security risk analysis. The security risk assessment, or SRA, is required under the HIPAA security rule. If you're dealing with electronic health records, and pretty much every office is anymore. I mean, nobody's running a purely paper practice these days. So if you're dealing with electronic PHI, you're required to comply with the security rule. And the first step in that is conducting a security risk assessment, where you figure out what risks you're facing in terms of your electronic health data. From that risk assessment, you would then want to develop policies and procedures. So the first major problem that I see is that practices will either have never done this and don't have real policies and procedures in place, or they have done one, but they did it, 10 years ago and 3 EHR software suites ago. So their policies and procedures and the risk assessment aren't up to date. The other version of this problem is where you have a whole set of policies and procedures, but you put them on a shelf and you never think about them. You never look at them. You don't engage in effective training. You don't review your policies and procedures and engage in internal periodic audits, for example. It's just, a book on a shelf that you never really pay attention to. And then when something goes wrong, you're unprepared for it. Those are probably the two biggest mistakes that I would see physician practices making.
Dan, what's perfect about this conversation is because my wife was a medical secretary once upon a time. So I get a lot of the terminology. I work in IT and technology myself. So I'm curious now because those two worlds tend to overlap, where a lot of the times you get these doctors' offices that they rely on these IT vendors or consultants to, for HIPAA compliance. Have you ever seen any examples of where that relationship has gone wrong from a legal standpoint?
Yes, unfortunately. One of my clients, it's a bit of a horror story, really. I mean, it came out fine in the end, but one of my clients basically outsourced her HIPAA security rule compliance to an IT vendor who was running basically a one-person shop. This guy set up her networks and her computers and all of that sort of thing, but he had misconfigured the firewall for her practice, and she wound up getting hacked as a result of that.
Mm.
So the OCR came knocking and tried to find out what happened here. And it turned out that the hack had occurred partially because this guy had just not configured things properly. She was then basically unprepared, at least initially, to deal with the problem. She ended up firing the guy, getting a new company to come in and fix all of that stuff. And because of the various remedial efforts that she went into, and I won't bore you with the details of all of that, but because she took remedial efforts quickly and effectively, and she responded to all of the OCR's inquiries, and we helped her navigate this process, she managed to get out of the investigation with no penalties applied. But it was costly and it was incredibly time consuming, and it was really, really emotionally draining for her. Not to speak ill of IT consultants, they're often very good at what they do, but they don't know HIPAA necessarily. HIPAA is a set of regulations and rules where if you're going to be dealing with it, you have to have sort of an understanding of the law. Um, not necessarily to the point where you have a law degree, but you've got to at least be familiar with the regulations themselves. So it may not be enough to just be really good with technology. And that's just one example of where I've seen, a real problem with making your IT guy your security officer, essentially.
Yeah. So Dan, let me ask you then, because some practices they tend to delay releasing records due to unpaid bills or administrative issues. Why in your estimation does that create compliance risk under HIPAA?
So HIPAA does not actually allow for withholding records because a patient has not paid a bill. In fact, HIPAA requires that you provide patients with copies of their records when they request them. There are some exceptions for that, depending on the nature of the records, but there is no exception for delinquent payments. There have been multiple enforcement actions by the OCR against practices that have refused to release records to patients who had outstanding balances. And the OCR took this so seriously that they made it a focus of their enforcement efforts for some time, and they still enforce against this. Patient access issues are one of their main focuses these days. So I would absolutely advise any physician practice, do not withhold patient records just because a patient has an outstanding balance. Now, that's not to say that you can't charge them the reasonable cost for producing the records, but that's different from saying, you owe us $20 on a copay, so we're not giving you the records. You can charge patients the reasonable amount for producing records. You can't demand that they pay their outstanding bills,
Yeah.
not before releasing them anyway.
Dan, let's land the plane on this because I'm sure there's people that are listening to this that work as PCPs and they're like, hey, I can't afford a full-time compliance officer. What's one or two things that you would advise them to do that can help them strengthen HIPAA compliance without spending a lot or making major changes?
So I think part of the issue here is the mindset that you go into HIPAA compliance with. I don't think one should approach HIPAA compliance from the perspective of how do I do this on the cheap? The better way to think about this is HIPAA compliance is a form of preventive medicine. Uh, when you are engaged in efforts to do compliance, what you're trying to do is protect against future problems that are likely to happen. The question is when, not if. Uh, what I can say is you don't necessarily need to hire a separate compliance officer. If you have people in your practice who are familiar with the requirements of HIPAA, genuinely familiar with them, not, I know that I'm not supposed to, um, say a patient's name on social media or something like that. If you have people who are well acquainted with the requirements of HIPAA, who may be clinical staff or administrative staff, they can serve as a privacy officer or a security officer. You can also split those duties between more than one person, so that you have a privacy officer and a separate security officer, or you can concentrate those duties in one person. What I will say, if you're going to have someone taking on the task of security officer, is that while they don't need to be a tech expert, it helps if they are at least conversant in technology so that they understand things like when your IT vendor is saying, well, we need to use this level of protection for our Wi-Fi network, because otherwise someone might be able to hack in through the printer as an access point to the Wi-Fi. You'll have a sense of why that actually matters. But the better way to think about this is not we're going to save a buck on the front end. It's better to spend the money initially so you don't have to spend it on the back end.
That's right. Don't do it on the cheap. I love that. I
Right.
love that say. Dan, thank you for the time and insights on this. We truly appreciate it.
Thanks again for having me, Mike.
And thank you to everybody out there for listening to another installment of Gosfield and Shea on health law. Listen, if your practice, you haven't revisited your HIPAA policies, your risk assessment, or patient access procedures, do me a favor. Now's a great time to give it a fresh look. Visit gosfield.com to learn more. Be sure to like, subscribe, leave us a review and comment if you like this episode, or share it with somebody who needs to hear it. As always, I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.